You everyone for joining. This seminar has specifically been organised for the Society of British Bangladeshi Solicitors, and a big thank you to Farida Hakim and Mahadi Hassan for organising this seminar. So the seminar is going to be delivered by James and I. James Shaw and I are both family law practitioners at One Pump Court Chambers. We both practice in children and financial remedies law. So James, what topics are we going to cover in today's seminar?
Thanks, Zubair. So, One Pump Cord has been delivering a series of webinars over October, and in that, both Zubair and I, with our colleague Andrea, tackled the issue of parental alienation in our private law cases. But for this webinar, we're going to touch on parental alienation, and we're also going to look at Part 25, both in the context of parental alienation as well as in general, and also the issue of conduct in financial remedies proceedings. So I think we'll start with parental alienation, which is certainly a concept that's coming up more frequently in my cases, and I'm sure yours as well, Zubair. Perhaps as a starting point, you can help us to understand how the courts now consider that issue of parental alienation.
Thank you very much, James. So, firstly, what is parental alienation? Now, in the past, the courts have taken the definition from Kafka's definition. What Kafka said is that alienation is when a child's resistance, hostility towards one parent is not justified and is a result of psychological manipulation by the other parent. And as I said earlier, the courts in the past accepted that as the definition of parental alienation and worked from that definition. And as a result of that, what we had was a focus on the child. And as you'll see from the definition, as you'll see from the definition, the focus is on the child. So when a child's resistance and the child's hostility towards one parent is not justified. And as a result of that, what we had was parental alienation experts being appointed by the court to give an opinion on whether or not the child has experienced parental alienation. I've given on the slides, you'll see an example of that in the case of RH. That's a 2019 High Court case in which the High Court paid high regard to the opinion of a parental alienation expert who in that case gave the opinion that the child had been alienated from the father. So that was the past approach. James, has anything changed?
Well, yes, I mean the short answer is it's a totally different approach. So I think what we direct you to is both Kafkas and the court's decision in Re C. So here Kafkas have moved to an approach where they're now looking at behaviors and patterns of behavior, much in the same way that you might approach the issue of coercive control allegations, where you're seeking to establish a pattern of behavior, and it's not necessarily the same specific behaviors in every case. It will be different in case specific. What there is a pattern of behavior that amounts to coercive control. We're now doing the same thing in alienation cases. Is there a pattern of behavior by one parent that has led towards the alienation of the child? And so it's a matter for the court to determine. And Kafka's have now amended their approach that is consistent with that, and they provide a number of tools. So where that really originates from is, as I say, Re C. And in particular, that case was before the president in 2023. And really that case tackled the fundamental issue of experts in family proceedings, and in particular parental alienation experts. But it also tackled the tricky definition question of parental alienation. And I think what's most helpful to get a clearer understanding of how the courts tackle this is to look at paragraph 103 in the case of Re C. And that's the president's view, where he expresses that, as with domestic abuse, it's the particular behaviours that is found to have taken place within an individual family that the court is concerned with, and therefore what the impact of those behaviours have on that child. And as a result, what that means is the court is not looking for a diagnosis. It's looking to establish facts, and then on a welfare analysis, apply the facts to consider the impact of the welfare on that child. So that's really the court's current approach, and it looks likely to me that that will remain the approach. But that's not to say necessarily that the court will not be interested in experts, and we're going to come on to experts later on. But just before I hand back to Zubair to consider CAFCAS in a bit more detail and what that can offer us as lawyers in the way we approach cases, I've just summarised from REC in this slide here really the three elements that we need to be aware of when we're either pleading pleading parental alienation cases, or rather perhaps we're defending them. And first of all, you need a child who's refusing or resisting contact. If that's the case, then clearly the court's going to be interested in what is the reason for that refusal, and is it relevant or related to the actions of one of the parents? And if that's potentially the case, can the court identify whether that parent, usually the resident parent, has engaged in behaviours that have directly or indirectly impacted that child, leading to the refusal? So it's connecting the dots, really, as you might in coercive controlling behaviour, but with the added complexity of the child's involvement being a key element to that. And obviously the child isn't directly going to be involved in the case. So we'll need to look at how do we establish those facts in the evidence. So as I mentioned, the CAFCAS tools are on their website, provide a lot of helpful guidance, and we're going to get into that in a bit more detail. So Zubair, this slide comes from a CAFCAS tool. What's your experience of tackling the issue of alienation since the REC judgment?
So first of all, thank you, Jane, very helpful for highlighting the correct approach now, or the approach that the courts are going to take. So as you say, the focus will be on alienating behaviours. And so for people who are either drafting documents or drafting statements, or people who are responding to allegations of parental alienation, what you will obviously be looking for is some sort of guidance or some sort of approach to follow. Now, there are a number of the law essentially is in REC, as James identified, but the tools that we can use for drafting statements or for responding to allegations of parental alienation, firstly, I'll suggest using the CAFCAS alienating behaviours tool. There is also a draft guidance issued by the Ministry of Justice on responding to allegations of parental alienation. Now, that guidance is still in draft form, but I think you can refer to it in a court case. But what you won't be able to do is persuade the court that, well, it's guidance that must be followed because it's still in draft form. But what I should say is that CAFCAS have said that guidance is largely consistent, is helpful and largely consistent with their alienating behaviours tool. So I think it can be referred to, but you won't be able to persuade a judge that it must be followed.
No, but I think that's a good point. And what you can do though is, if you're defending the alienation claims, and you're up against perhaps social work or guardian evidence, which is suggestive of alienation behaviour, you can scrutinise whether they have properly considered the CAFCAS tools or the guidance as either points in your witness statements or points in your cross-examination.
Absolutely. James, I mean, have you had an experience of that? I certainly have, where I've cross-examined a social worker from the local authority, and where it appeared the local authority didn't have anything equivalent to the CAFCAS alienating behaviours tool. Have you had an experience where you've been in court and you've scrutinised the author of a report, a welfare report, for not using that tool?
Yes, I think it's unfortunately common that you have a Section 7 report, perhaps by a social worker, which on the face of it is supportive of the resident parent. But when you get down to the details, that social worker hasn't considered or applied any of the toolkit that CAFCAS offer to identify whether behaviours are present. And so what appears to be a positive, supportive report for the resident parent can be undermined quite quickly. So the CAFCAS alienating behaviours tool here, this sort of flowchart, highlights that there are a number of reasons why, in CAFCAS' view, a child may refuse contact. and only 1 out of 5 of those in that second row is alienation. So there are 4 other potential headings of reasons why refusal might take place, which are not alienation. And so one task will be to try and distinguish the behaviours that point towards alienation rather than another heading. So, for example, appropriate justified rejection might be as a result of the behaviour of the other parent, which is not necessarily abusive, but relevant to parenting. It might be because they've experienced domestic abuse, and that could be an issue that the court's looking at as well. It might be that simply as a result of the separation, the child has either attached themselves to the resident parent and is demonstrating some loyalty to that parent, or it might be that there's actually a psychological attachment issue that the child has, and that's underlying the reason for refusal. Or it might be that there's a combination of these factors, and that's where the complexities can arise. So in these next slides, we've got a number of examples of where a child has refused contact, and there could be various reasons for that that might indicate alienation. So usually the child will be asked by either a social worker, or if there's an expert involved, perhaps a psychologist, their thoughts about the other parent, and in an appropriate way try and identify the child's reasons for refusal. And what you're looking for is the reason given on the face of it unjustifiable? Is it disproportionate to the outcome? For example, the child says, my daddy shouted at me, and as a result, I never want to see him again. That might be an example of an unjustifiable or disproportionate reason or reaction that will make you start to think, hold on a minute, are there things going on in the background in this child's life that is alienating him from the other parent? Is the child saying negative things unprompted? Is the child coming up with a history that on the rest of the evidence doesn't seem to be consistent? Kafkas will consider that revising history, or washing out the good memories in favour of only negative memories. Guilt is something that Kafkas in the toolkit highlight for both the child and the parent. So when the child or the resident parent talks about the other person and the fact there is no contact happening, do they ever show any regret or guilt about that fact? Because if they don't, it might be that the environment in the home is one where there is no positivity about the other parent, and that is an example of an alienating environment and behaviour. And of course, you have scripted or similar language used by the child, which seems odd. It strikes you as not usual language that the child would use. Or, for example, you might have in the written evidence a number of meetings where the parent has said something and the child has said something totally separately, which are extremely similar or in fact the same, which is, I think, usually a demonstration of discussions that have been going on between the parent and the child behind the scenes, resulting in the same language being used. So Kafkas gets you to scrutinise child's behaviour in the context of the evidence and the resident parent in the context of the evidence to flag up the pattern of behaviours that might be or that might amount to alienation. So I'm just flicking through these slides because one thing that we'll often come into contact with, Zubair, and I'm sure you've seen this, is where one parent alleges abuse by the other parent, and conversely, as a cross allegation, that parent alleges alienation. And that's quite a tricky issue for the court to unpick. So it might be that we have a fact-finding hearing on cross allegations of more typical abuse allegations versus alienating behaviour. Or it might be that we have the fact-finding on typical abuse allegations, and then the alienation or question of alienating behaviours arises after that, in which case you might find yourself tackling that issue at the welfare stage at the final hearing.
Yeah.
So once findings have been made, the question is what to do next, or equally, if findings haven't been made, what to do next. And it might be that you're at the welfare stage and the appropriate outcome is a final order, depending on the findings. Or it might be the court decides it needs more evidence to resolve the proceedings justly. So what's your view, Zubair, on where we could go next in the case?
Well, as you say, James, there's a number of options. One of the options, and the practitioners will know from Practice Direction 12J, paragraph 33, that after a fact-finding hearing, the court must consider whether an expert should be appointed, including for the psychological assessment of the parties. So, as you say, firstly, there's a number of options, but one of those options is at that stage, the point after a fact-finding stage, is whether or not an expert should be appointed. And just touching, I mean, I know we've said earlier that, oh, not that we said, the law now is that parental alienation is not a diagnosable condition. So you can't have an expert, an expert can't be instructed to give an opinion on whether or not parental alienation has or has not occurred. But there is still a place for experts in this whole issue of parental alienation. Firstly, as you've highlighted, James, one of the issues that CAFCAS will be looking at are whether or not the child wants to spend time with a non-resident parent. And that can only really be identified from looking at the wishes and feelings. So a welfare report, even if it's earlier on down the road, may be helpful, a Section 7 report in which the child's wishes and feelings are obtained to identify whether or not their reasons for opposing contact are justified or not. We will need some sort of independent welfare report. So in that sense, a Section 7, a Section 37 report would always be helpful. But as I said earlier, a psychologist report can also be helpful. And it could first be helpful to identify the impact on the child as a result of such alienation. And similarly, a psychological assessment of the parent or parents can be helpful in identifying whether or not or the reasons behind their alienating behaviors if established, and secondly, whether or not or what remedy really is available for that situation.
That's right. I mean, REC, as I mentioned, tackled the issue of experts. I mean, somewhat unhelpful in the sense that it doesn't take us any further forward, but these paragraphs on this slide, 87 and 98, are from REC, and essentially what the judge is saying is, well, who is an expert, you might ask? Well, an expert is someone who gives expert evidence. That's the definition in the family procedure rules, not particularly helpful. So it's a case where if you need expert evidence and you have an expert in mind, you just have to argue at a hearing in front of the judge that your expert is the relevant, has the relevant expertise in this area. But I've given some examples in this slide as to what type of issue you might want to draw out from the evidence to help you think about which expert you might need. So I think, Zubair, you touched on a really important point that you want to know the wishes and feelings of the child. That's most commonly derived through a Section 7 report. But that can also come through a global family psychological assessment. A psychologist will be able to tackle the issues of attachment. And like I say, as Kafka set out before in that flowchart, if attachment or alignment is a key feature, a psychological assessment is going to be the type of expert assessment you need to look at that issue. For instance, you might have a case where a child, because of whatever experiences the child's been through, has aligned themselves with the resident parent and adopted perhaps some of the resident parent's negative views of the other parent. Well, is that an issue of alienation or is that an issue of alignment? And you might need to understand that difference in order to know, like say, the remedy, how you might tackle that issue. For example, a therapeutic or family therapeutic remedy, as opposed to, for instance, another outcome which might be a hard transfer of residence, where the impact for a child who has aligned themselves to the resident parent would be quite significant. And the court's going to need to understand the difference there. Another helpful piece of information from REC is understanding what is a psychologist in the context of expert evidence. Because the issue in REC was that the expert in that case was not regulated. So what was highlighted from REC is there are two types of regulation in this country. You have the Health and Care Profession Council regulation, and they're dealing with the forensic psychologists, and they offer protected titles such as clinical psychologist. And then you have the British Society, British Psychological Society, and more commonly they're dealing with chartered psychologists in the academic field, so post-grad or postdoctorate psychologists. And I think the guidance, as you mentioned before, is really suggesting that you want a clinical psychologist to tackle the issues of these family dynamics where alienation or affinity or alignment may come up. But really, what is an expert? Well, RECE tells us you don't have to be registered. You just have to persuade the court that your expert has the right expertise. But really, what the guidance is telling us is that in most cases, you want a regulated expert because you have the means of going to the regulator to complain if they do a poor job, which is the security really you're looking for. Whereas an unregulated expert, not only do they not have access to standard tools, they may not have recognized qualifications, but ultimately, if they do a poor job, there's no one who's going to hold them to account. So you don't have that level of security. You've mentioned Section 7 reports. You might also have Section 37 reports where there are intractable no contact issues, because of course that is an issue that may be causing significant emotional harm. So the local authority are likely to be involved. You're likely to have Kafka's guardian involvement, especially where there's no contact happening or serious allegations of abuse, or there's complexity. Perhaps one child wants contact and there's a second child who doesn't want contact, and you have a difference then of opinion between the children. You might have neurodiversity in the children or in the parents, and that might be material to the reasoning. And that's the final paragraph of that slide is what you referred to earlier, which is practice direction 12J is saying to the court, you do need to consider the issue of whether an expert is necessary in this case. But prior to the court dealing with that, obviously we as lawyers will have had to have thought about it carefully and put together a properly constituted application for the court to consider.
Absolutely. Jamie, we'll touch upon proper, for those listening, we're going to touch upon applications, Part 25 applications, the test and what must be considered in trying to persuade the court that the expert that you're proposing is actually necessary for that case. So we will touch upon that. We will touch upon that. Shall we do that now?
Yes, I think so. Just to wrap up the experts in this one, just for the purposes of the slide, these paragraphs comes from that Family Justice Council guidance. And so it's a really helpful, I think, which is why I put it on there, paragraph as to what are you looking for in an assessment of a child and what are you looking for in assessment of the parents. And actually, I'm sure most of us come across this in our practice, either in public or private law. Psychological assessments are usually quite standard, and case by case they might have some differences. But really, for the case of an alienation in private children, there's nothing especially different that you're looking for from a psychologist. You're trying to glean the same sort of issues and then apply those to the facts that you've either established or may seek to establish at the next hearing. This case here that I wanted to highlight as we come on to Part 25s in the context of alienation is a useful case where there was a psychotherapist instructed who went on to complete work with the family and then produced some reports. And in this case, even though the original instruction came under Part 25, the subsequent reports the court found were not pursuant to Part 25. They were a matter of therapy rather than of expert opinion. And in the end, His Honour Judge Levy disallowed that psychotherapist from being called as a witness because they were no longer considered to be an expert under Part 25. And there was he distinguished between fact and opinion, and an expert piece of evidence obviously is a matter of expert opinion, and the court will give due weight to that. Whereas the psychotherapist report fell into the category of fact, essentially. Although the psychotherapist will be giving or expressing opinion as to the engagement of the family, the psychotherapist actually went on to make recommendations about transfer of residence, which was beyond its remit. And so this is an interesting case for where you might have therapist reports or clinical reports which have come into evidence but are not under Part 25, and the way the court deals with that. And then lastly, we have the case of GB, which is His Honour Judge Middleton Roy in Watford. It was an appeal from a district judge, and this was interesting because it tackled an appeal about essentially the letter of instruction for the psychologist, and secondly, whether that instruction was necessary. So the appeal was allowed on both grounds. The psychologist, as you see in the letter of instruction, was asked to comment on whether the attitude of the parents toward each other was positive and negative.
Yeah.
And it's on a judgment of Roy to the view that that's not for the expert to decide. That's a matter for the court to decide. And secondly, the letter of instruction asked the expert to express a view about whether alienation was present, and if so, what the impact on the child was. And again, consistent with Re-C, His Honour Judge Middleton Roy said no. That's a question for the court to decide whether alienation has been present, and therefore what the impact on the child was. So I think the district judge was criticised, I think it's fair to say, about allowing those questions to be put. So that's an example on the ground of questions being included in the letter of instruction, that on appeal the courts had to say no, that's wrong. And the second thing to take from that case is, and this is relevant to all Part 25 applications, the judge did not actually address in its decision to grant the expert instruction why it thought the expert was necessary, and it provided no reasons for why it rejected one party's view that it wasn't required. And so as a result, I've included the view of His Honour Judge Middleton Roy, where he emphasises the importance to justice of reasons being given. So I think that's something to flag. If whether you're opposing or seeking instruction, it's important the judge gives reasons.
Absolutely.
You don't want to end up in an appeal situation and then back to square one. Especially for the sake of costs, if not time and everything else. So going back to basics, though, Zubair, perhaps we can just summarise those Part 25 basics.
So if there's one word you're going to take from Part 25 applications for the appointment of an expert, if there's one word you're going to take away from this seminar for Part 25 application, it's the word necessity. And that test, the test of necessity, applies equally to financial remedy proceedings, so applications for the appointment of an expert in financial remedy proceedings, and also children proceedings. So there's no difference in test for financial remedies or children. Now, so the next obvious question is, what does necessity mean? Now, very helpfully, in the case of H&L, Sir James Munby at paragraph 3 has given us really the answer to that question. The first sentence, first, necessary means necessary, but later on in that paragraph, we see that we have a bit more of an expansion on that definition, where the court was able to say that it has a meaning laying somewhere between indispensable on one hand, useful, reasonable, and desirable on the other hand, and having the connotation of the imperative, what is demanded, rather than what is merely optional or reasonable or desirable. So that, in essence, is really, if you're trying to delve into the definition of necessity, that's really what it is. But when you've gotten a Part 25 application, the court's focus will be on the word necessity and whether or not that application or the appointment of that expert is necessary or not.
I always think of it when I'm making Part 25s or opposing them is when the court's deciding the case at the end, will it really be able to do so without that evidence? And I think that's the test you have to apply. I think judges often say, well, it's useful, but is it necessary?
Absolutely. And I mean, if the very next slide repeats pretty much exactly what James has just said. So when we look at the approach, judges are expected to scrutinise and carefully all applications for the instruction of an expert, and only allow them when satisfied that the expert's opinion is necessary to assist the court to resolve the proceedings justly. So James, that's exactly what you said, and that is, if we are going to approach a Part 25 application, I would suggest that's the angle that it should be that should be taken.
So when you think, well, can the court properly conclude the case without this evidence? When you're making your application, in the Part 25 notice, you can then address those points. So Section 13(7), when we're dealing with our private children cases, same for public law, of course, sets out so the list A through H of the factors the court will consider. Now, obviously, it's emphasising the relevance of the expertise. It's emphasising the court to scrutinise what evidence it already has. Does the evidence proposed add anything? Does it fill a gap in the evidence that is really necessary for the court to resolve that case justly? And so in the case of parental alienation, obviously we're looking at the attachment of the children to the parents and remedy in therapeutic sense. And obviously in financial proceedings, you might be looking at valuations of various different types of assets and so on, or disposal perhaps of particular assets that might be more difficult. In the context of financial proceedings, then we have a similar list in the rules under Part 25(4). And so really we're looking at expertise, we're looking at time, we're looking at cost, and we're looking at the necessity of it in the context of the existing evidence.
Yeah. So James, I mean, just on that very point that you mentioned, the list that we have in Section 13(7) of the Children and Families Act 2014, and also Rule 25(4) of Family Procedure Rules. I mean, what I would advise anyone who's drafting a Part 25 application is to look at those, to look at that Section 30, look at Section 13(7) and look at Rule 25(4) for financial remedy proceedings, and make sure that you are able to address that. I wouldn't say it's a criteria, because it's not a criteria, but essentially trying to address those factors. It's not a criteria because it's simply factors which the court should take into consideration, but there's no requirement that all of those factors are ticked off before a decision is made in respect of a Part 25 application. But that would be my advice to anyone who's preparing a Part 25 application.
Yeah, and the more detail you can put into your Part 25 notice, I think the better prospects you've got.
Yeah.
Because the court, I think, will appreciate, in my experience, certainly judges who are, as we know, pressed for time, appreciate concise but detailed reasons in the Part 25 notice for the application that they can understand before going into court.
Yeah.
So obviously this Part 25, Practice Section 25(c) really is emphasising the point that the court needs to consider what evidence does it already have. And if we're making a Part 25 for an expert, obviously we need to provide, if we can, a number of different potential CVs, or we might be able to agree with the other side the identity of an expert. But if it's not evidence that's capable of being provided by a party, or in the case of private law, it might be that you already have input from the local authority, not as a party, but as, I suppose, third-party evidence, then you're going to be on better ground persuading the court that your expert is necessary, because it's not otherwise going to be able to get that evidence in the proceedings.
Absolutely, that's exactly it. I mean, and in children proceedings, the previous slide, it drew everyone's attention to Practice Direction 25(c), paragraph 3.10, subsection F, and that's where where it's proposed an expert give evidence in children proceedings. Then what the application for the expert evidence, what it must address is why an officer from CAFCAS or the social services can't give that evidence when conducting their usual inquiries.
So, well, I just make sure the battery is on charge. The other question is, well, what happens if you have your expert evidence and that's been on a joint instruction, but you're not happy with it? Zubair, perhaps you can just dive into that issue.
Yeah, I mean, I won't. This is a long slide. What those sorts of applications are called, they're called Daniel and Walker applications, and helpfully, in a more recent case, so Daniel Walker's case from 2000, in a more recent case of GANEL, at paragraph 28, we have essentially the criteria for such applications. So in answering the question, can you have your own expert if there's already a single joint expert in the case? Yes, you can, but you will be asked to persuade the court that the criteria, as I've set out on that page, is met.
And I would have thought you would have need to have raised questions of clarification, perhaps under Part 25. In each instruction, you have 10 days after the receipt of the report to raise questions of clarification without incurring any further costs. Those questions are limited to clarification questions, but you probably have to go through that process before you'll be able to persuade a court either that that report is defective and you need another one, or you need an addendum or something like that. The other thing I wanted to mention on the back of what you say is something that I've come across, which is the use of shadow experts. So if you have financial proceedings and you have, I suppose, that your client has some financial means and you're not able to get a second report, or you don't think you'll be able to persuade a court for a second expert, you might be able to afford to instruct a shadow expert to give you some advice on that report, advise you on what questions you might want to raise either in clarification or indeed in cross-examination. So even if it's a case that you don't think you'll persuade the court to allow you to instruct a second expert, a shadow expert might be able to assist you in the preparation of your case or in the preparation of questions.
Yeah, absolutely.
So I think moving on then to our final topic, Zubair, conduct. What are we talking about when we say conduct?
So there's essentially, I mean, there's different types of conduct. I referred at the very end of that slide to the case of OG and AG, paragraph 34. I think it was Mr. Justice Mostyn in that case. He set out the four heads of conduct, the different types of conduct. But if we were to summarize conduct, I'll say there's two general types of conduct. You've got marital conduct and then you've got litigation misconduct. So marital misconduct and litigation misconduct. In today's seminar, what we'll be focusing on is marital misconduct. And when we look at litigation conduct, that can be addressed in a number of ways. There's cost orders. There's also Norris add-backs, which can also be made, but we won't be delving into that today. Perhaps that's for a different seminar. So just looking at marital conduct, we obviously know that conduct is relevant. I mean, we know from section 25 to subsection G of the Matrimonial Clauses Act that the conduct of each party is relevant, and if that conduct is such that it will be in the opinion of the court inequitable to disregard, that's also relevant. But over the years, we've had so much case law on conduct, and this year we've had some more case law on conduct. And James, we've got the case of the very recent case of forgive me, I've got NNJ. What's your from reading that case? What's your overall view on the situation or state of conduct cases right now?
Well, I think the starting point is to, I think, accept that even though in our private children practice, domestic abuse has come to the forefront of many of those cases, and the understanding and appreciation of domestic abuse is growing, I would say, within the family justice system for private children. For financial remedies, the court is not looking at it with the same lens. So it's a high bar, is what Justice Peel says in NJ. Even if you consider that domestic abuse is immoral, deplorable, or the actions are what in any other case would be considered abusive and relevant. In the case of conduct in financial proceedings, there must be a financial consequence arising from the conduct. And there's also a question of proportionality, because I think what NNJ really highlights is the need for scrutiny by the court to consider whether it's proportionate to go down the route of investigating allegations where the issue might be covered under the other Section 25 factors. For example, if the consequence of the alleged conduct is that the person is no longer able to earn as much as they otherwise would have, well, earning capacity is already a factor under Section 25. So even if the facts were proven, well, the outcome or the consequence of those facts is still an issue that the court's going to consider. So it doesn't need, or it's not proportionate to go into the investigating phase.
Absolutely. I mean, and James, I mean, what from my reading of NNJ, the key paragraphs are essentially 38 and 39. At 38, subsection 3 is what the court is exactly what the court says. I mean, it repeats exactly what you've just said, forgive me. In that the court's going to be considering the Section 25 factors anyway. That includes someone's earning capacity. And when you look at someone's earning capacity, if the argument is, well, their earning capacity is decreased because they weren't allowed to work, well, their earning capacity is assessed anyway, and that's a factor that the court will take into consideration when deciding what assets or how the assets should be distributed. But the question of whether or not personal conduct can be raised, and there should be an additional there should be a fluctuation in the award in favor of one party or the other. That's something that in NNJ, the court really struggles to say, well, yes, this is the test that should be applied in those sort of situations. The court really says that those scenarios where personal conduct is so bad and there should be an additional award, those scenarios will be exceptional and will be very few.
Yeah, I think that's the reality. So, I mean, in practical terms, what we get from NNJ, and that's consistent with recent case law, is we need to be thinking about the issue of conduct right from the very start. I think we probably need to be advising our clients robustly that anything but quite exceptional abuse with a financial consequence is going to be disregarded by the court. So it is quite common, and I see this quite often, I'm sure you do, Zubair, that conduct is raised in the formie, and what we see is a fairly typical narrative of domestic abuse that we would often see in our private children cases, and that may indeed be relevant if it was a private children case. But there is no obvious financial consequence that is material to the outcome in the financial proceedings, and almost certainly the court is unlikely to consider it a conduct case. And the reason why we need to perhaps be more wary of that is that the courts, I imagine, are going to start getting fussy with cases of conduct that are run that don't have any merit.
Absolutely.
And there might be cost consequences for that. So we do need to be a bit more robust.
Absolutely. I mean, in the previous slides, I wonder if I can go back. I refer to the case, the case on top, the case of Kairova, 2023 case. If I think we close this. If there is, I mean, if somebody is, if you've got a client who wants to raise conduct argument, first of all, I'll highly recommend you to consider the case of Kairova, the 2023 case there. There's a two-stage test that the court will apply, and that's between paragraphs 43 and 45. I won't repeat what the test is, they're lengthy paragraphs. But what the court essentially will be looking at is whether or not there is an identifiable negative financial impact on the parties as a result of the alleged wrongdoing. And it has to be pleaded at the very earliest opportunity. I believe it's paragraph 46 or 47 of the same case, in which the court says it's not good enough to simply state in your formie that that I reserve the right to plead conduct at a further stage. And the court will take a negative view of that if that's the approach that you're going to take. If you're going to raise it, it has to be pleaded in precise terms at the earliest stage. And I set out in that, I think, I refer to paragraph 46 there.
So I have had a few cases where at the FDA, the judge has decided that the issue of conduct will be re-looked at the FDR. And essentially it's kicking the can down the road a bit. Yeah. I suspect the judge thought it was probably a case, not a case of conduct, and if the case settled, it wouldn't have to deal with it. But I think what's going to happen now is there's going to be pressure on the judges to scrutinise the issue of conduct at the first hearing, and I suspect the party who is resisting the conduct is going to be asking the court at the FDA to rule that issue out.
Yeah.
And so if you're not prepared with fully particularized allegations in the formie with reasons as to why there's a financial consequence, your client's going to run the risk of that issue being ruled out before you've had a proper chance to plead it.
Yeah.
So I think we need to be sort of front loading the issue of conduct in the formie with either an attached statement, or if you can fit it into the box, do so. What I wanted to highlight on that is just flicking forward again, apologies, is the case of A&R. It's a district judge case, but what we've got here is a case that was listed for a conduct case management hearing in July. So I think that listing was given before N&J was handed down, but the conduct case management hearing actually occurred after N&J, so it's referred to. And so this was a 3-hour case management hearing purely listed to consider the issue of conduct. And prior to that, the parties have been directed to essentially file schedule statements and response statements. And A&R is a helpful example of an on-the-ground decision looking at the allegations of domestic abuse and concluding that the high bar was not met. And in the case of A&R, if the facts, if they were proved, would have amounted to coercive and controlling behaviour that would be immoral. However, the court concluded that even if it was proved, that would not have a material impact on the outcome of the financial proceedings.
Yeah.
The abuse didn't jump out of the page in the context of whether it's inequitable to disregard that conduct.
Yeah.
And so it was dismissed. And as a result, the evidence relevant to that was to be taken out of the case. But it might be that we don't have the benefit of specific hearings for conduct because the court hasn't got time. It's obviously extra costs. So we need to be prepared to deal with it within the FDA. Because there wasn't a cost order in this case, but if you had a separate listing for a conduct case and that turned out to be completely without merit, the court might want to emphasise its disregard for that by making a cost order.
It's surprising, yes, there wasn't a cost order, as you say, because these sort of hearings are usually ring-fenced, aren't they, when it comes to costs. But in any event, I mean, James, I think that concludes our seminar. What we're going to do now is just open the floor for questions. So if you've got questions, please post them in the chat and we will try our best to answer them.
So we've got the chat box up here. It does say the chat's disabled, but we have also received your comments, or at least the ones at the beginning. So perhaps we can try and use that anyway.
Yeah, give it a go. If it doesn't work, we'll call for help.
We have our laptop, so if anyone needed to email us separately, then that's going to work as well.
Yeah. What? Yeah, so can we receive the presentation slides, please? Yes. So what we'll do is I will get in touch with Farida and I will through our chamber's PR executive and marketing executive, I'll find out the best way to share the slides. But I'll make Farida aware of how the slides can be shared to you.
Yeah. Okay, great. We've got some questions coming in. Ooh, so perhaps you can tackle that one. I think that Shireen, I think that does touch on.
So do you feel conduct has become redundant as a Section 25 factor? I can't say it's become completely redundant. What I'm going to do is I'm going to repeat paragraph 39, subsection 2 of N&J, and I think that's really, really helpful. And in that case, Mr. Justice Peel said that he accepts that statute does not specifically refer to financial consequence. So the statute doesn't specifically say that conduct can only be argued if there's a financial consequence. And it's therefore wise not to rule out completely, theoretically, possibility of conduct being taken into account absent such financial impact. So there doesn't have to be a financial impact. Nevertheless, as the review of the authorities above suggests, such cases will be vanishingly rare.
Yeah, I think that's right. So they put the bar really high for a conduct element, and they've emphasised the fact that even if there is abuse that has led to a consequence, that consequence might be covered under the other headings in Section 25. So I think the question highlights the really important point, which is the court's looking at the consequences. If it's already covered, why bother going down the conduct investigation route, because it's disproportionate?
Yeah.
And as a result, I think N&J hits that nail on the head, which is to say they're going to become vanishingly rare. So redundant might be one way of expressing it. Vanishingly rare, I think the answer is the same, which is conduct cases are going to be few and far between, certainly.
Yeah.
Okay, the next question on here. In terms of experts for parental alienation, do you have suggestions such as psychologists? So I think you're likely to have input from a social worker and a guardian, come what may. I would certainly recommend a clinical family, child, adolescent, and adult psychologist to complete an assessment. Usually, you want a global assessment because you need the dynamics of the family. You want to understand the child's attachment to the resident parent versus attachment to the non-resident parent. You want to understand if the child has any neurological functioning atypical characteristics that might have a bearing or an impact on their decision making. And what you want to know is this a case where there's a therapeutic remedy? The frustration is that these things cost money. I mean, if you need a course of psychological family therapy, either you're going to pay for it or you're going to have to wait an enormously long time for the NHS to cover it, which they probably won't. In which case, the longer things are left, the more entrenched they become. So if your clients can afford it, then a psychological expert assessment can make a specific recommendation. For example, the recent case of mine, an experienced global family psychological assessment highlighted the emotional attachment of one child to the resident parent, and indicated that the child and the resident parent needed separate courses of cognitive behavioral therapy in order to change their attitude toward the other parent. And that would be the therapeutic remedy. And of course, what the court's considering is, does it go down that route, or does it transfer the residents and take more of a practical resolution alongside some therapeutic support? So I think psychologist is going to be the most common expert in alienation cases, because you're looking at that family dynamic.
Yeah. The next question from Behzad Sharmi. So the question is how to respond to an LSPO application, the strategies. I mean, this seminar isn't really covering LSPO applications, but what I would just say on the top of my head is just make sure you consider the statute. I think it's section 22 ZB subsection 1 of the Matrimonial Causes Act. And it's also the case, the key principles are summarized in the case of TL and ML 2005 EWHC 2860. So just make sure you go through the criterion in case law and in statute. Let's just check if there's any other questions.
Yeah, I think if there's anything more specific to the LSPO question, you could email us. We'd be happy to respond to that.
Yeah, I mean, our emails are on Shane's website, so just find our profiles if you can.
Yeah, we might be able to put it in the circulation of the slide. We can put that in there.
Yeah,
yeah. I'm conscious of time. I think we said now. I mean, we're happy. If there are any other questions, I'm sure we're happy to answer them. But I don't want to keep everyone on the line any longer than you have to be, because I'm sure you've all got things to do this evening.
Yeah.
But if anyone has any other questions, feel free to put them in. Otherwise, we'll just wait for a few minutes and then we might wrap up if there are no further questions. Well, here we go. So we've had a question in, sometimes if we feel like in any child contact proceedings, opponent, legal aided solicitors, counsels are playing delaying game. Yeah, for example, 4-hour fact-finding hearings should be enough, but they're asking for 3 days. So we've got listing delay. Or they're not mindful of an amicable solution. So that's a tricky one. I mean,
sorry, Tom.
Well, I was just going to, my initial observation was the issue of listing delay. I was before a judge recently in Maidstone, so I suppose within Kent, and we were told that I think the DFJ there has indicated a view that all private proceedings should not be given any listings greater than 2 days. And we were before the judge on a 4-day listing. and I think the judge made the comment, which we were all thinking, which was, well, it's very well listing it for 2 days, but we've got 4 days worth of evidence.
Yeah.
What are you going to do in reality? And in that case, I mean, we all agreed that it was a 4 day case, but I think the question gets to the point, which is when you're the resident parent
Yeah.
and you've got the
Yeah.
benefit of legal aid, the, the delay tactics, the entrenchment effect of delay are all things that work in your favour, and that's a real problem.
Yeah.
I mean, just
I think that's yeah. If it's
bang the drum of proportionality
yeah.
and necessity, I think that case I referred to about the therapist, the psychotherapist, where the judge actually made expressed the view that the case was 3 days and the key witnesses were the parents and I think the guardian, and it wasn't proportionate for the psychotherapist. So that case emphasised that the courts do need to scrutinise proportionality of the evidence. What really are the issues, and what witnesses are necessary for the court to decide the issues.
Yeah.
And you might be able to. I mean, a 4 hour fact-finding hearing might be on the extreme end of short, but if the facts for that case say 4 hours because it's two witnesses on nominal issue, sorry, a short number of issues, then maybe you're right. But bang the drum for that.
Yeah. I mean, yeah. I mean, what comes to my mind is just the case of K&K. Just go through the test of fact-finding hearings and try and persuade the judge that well, for a 3 day hearing, it's not
cut down the issues if you can. Yeah.
But thank you everyone for your questions. Thank you for attending. Thank you to Farida and Mahadi for organising this. We hope you found this helpful. And we will try and circulate the slides so everyone can benefit from them. Thank you again and take care, everyone. Enjoy your evening.
Bye, everyone. Take care.
Thanks.